afternoon, everyone. My topic is the current trends on in the development of company law in Romania. Well, company law is a dynamic field of law, as we all know. Therefore, it poses a challenge when attempting to articulate new insights in a brief format, such as a short presentation. However, in my presentation today, I will try to give you some new insights, aiming to offer you a fresh perspective, different from the previous discussions. So in my presentation today, I will try to explore some fundamental characteristics of companies within the Romanian law context, more specifically talking about the number of members, the capital requirements, and the transfer of participations which represent members' rights. So let's start with the regulation. In December 1989, the Soviet-style dictatorship was overthrown, necessitating the re-establishment of a legal foundation for a market economy. As we all know, essential for market economy are companies. Therefore, the law on commercial companies was established relatively early in the autumn of 1990. We're talking here about the law number 33 of 1990. Currently, the law on companies and commercial companies adopted immediately after the regime change still remains in force. However, it has been modified more than 45 times, some amendments being considered so significant, so important, that they are considered to be corporate law reforms. Therefore, law number 31 of 1990 has ripened for recreation because of these numerous amendments that we're talking about. The conceptual unity of this law has been broken. Here are the 5 types of companies that exist in Romanian law. As you can see, the general partnership, simple limited partnership, limited liability company, joint stock company, and the limited partnership by shares. Here what I would like to mention is that a limited liability company can, and in exceptional cases a joint stock company, can be set up, can be established unilaterally without having a contractual character, yet it will still be considered a company. Thus, there exist some companies that cannot be of contractual nature. For example, the single-person limited liability company or the single-person joint stock company. Here you can see some statistical data regarding the 5 company types which are regulated in Romania. Practically here, what is worth noted is that, as you can see, the limited partnership by shares, it's almost inexistent in practice. So as practice shows, this form of companies is not required. Then also, as you can see, limited partnership, general partnership, these forms of companies are also very few because these kind of companies are being superlated by the limited liability company. So, as a conclusion from here, we can say that in practice there are 2 common types of companies that are, let's say, existent or abundant in the practice, which are limited liability company and joint stock company. Moving on to the participations, according to the Romanian Civil Code, each company type comes with its own specific form of, distinct form of participation. More precisely, for limited liability company, these interests are represented by company shares. For joint stock company and limited partnership by share, it's stocks. And for general partnership and simple limited partnership by interest shares. The transfer of interest shares signifies, of course, the transfer of a contractual position requiring the consent of all the other contracting parties. This approach, what I'm talking about, is due to the fact that in this kind of companies, the personal qualities of the associates is important, and here the identity of the incoming party is very crucial, particularly because in case of the general partnership and the members of the general partnership and internal members of the limited liability partnership bear unlimited liability. And I would also like to mention here that in the limited liability company, associates may freely transfer their shares among themselves, but it must be said that for outsiders it doesn't work the same, because for outsiders this is only possible if associates holding at least 3/4 of the company's capital approve. This rule, this 3/4 rule, officially was meant to protect the unique character, the unique aspects of a limited liability company. And it was, let's say, a mandatory norm. But law in 2020, and here I'm talking about law number 223 of 2020, introduced changes in this aspect, and through this norm, much more flexibility is allowed in companies' governing documents. So this means that now this norm is not mandatory anymore. Here I would like to mention that talking about this flexibility, this lets companies issue shares that are almost as freely tradable as securities. Though technically it is not, they are not allowed to issue these shares as securities. And of course, this creates a conflict because the law still prohibits these companies from issuing actual securities and declares a criminal offense turning company shares into securities. In our opinion, this 2020 law didn't mean that members' approval for selling shares should be ignored, but in fact, rather turning this 3/4 majority into a unanimous decision is legally acceptable. However, reducing it to a simple majority should still respect the legal requirements, the legal limits, which makes securitization illegal. But of course, making shares fully tradable as if they were securities remains illegal. So legally, to conclude here, I would like to say that legally the maximum flexibility which we could apply would be a simple majority to approve these transfers, but the total elimination of this approval, of course, it could be problematic. Lastly, let's discuss stocks, which are shares issued by joint stock companies and can be traded freely as securities. In Romania, there used to be these shares used to come in two forms. First, the registered stock, registered shares and the bearer shares. Registered shares are the ones which have the owner's name on them. Bearer shares do not have the owner's name on them. Therefore, this makes them anonymous and also really easy to transfer. However, due to concerns regarding money laundering and terrorist financing, in Romania, they passed the law in 2019, which got rid of bearer shares. So now with this new law, no new bearer shares are allowed to be issued, and all bearer shares that already existed have to be converted into registered shares. Talking about the capital requirements, in the case of joint stock company and partnership limited by shares, the capital requirement is of a minimum of 90,000 euros, with lei of 90,000 lei, which is approximately 18,000 euros. And here we have a problem because the EU requires a minimum amount of 25,000 euros, but here probably it's the inflation altered this amount of money. Of course, the government may amend the minimum value of the company capital, taking into account the exchange rate every 2 years at most. And there are also some specific requirements. For example, in case of companies that are pursuing leasing activities, this the capital is of 200,000 euros, or 5 million euros in case of commercial banks. In talking about this capital of the limited liability companies, for a long period this was set at 200 lei, which is approximately 50 euro. This approval was divided into, this capital was divided into equal capital shares, and also talking about the minimum nominal value, this was originally set by law at 10 lei. This means that the limited liability company set with the minimum capital of 200 lei could have a maximum of 20 company shares with a nominal value of 10 lei. However, there was no obstacle of setting a higher nominal value. For example, a limited liability company could be created with 2 company shares, each of them with a nominal value of 100 lei. But law number 223 of 2020, however, abolished this minimum capital requirement and the minimum nominal value, which means that now in Romanian law, the nominal value of a company share can be set, any nominal value can be set, which means that a limited liability company can be created with a share capital of only 1 lei. So, for example, the establishment of a limited liability company from using capital of 2,000 lei can have company shares with a nominal value from 1 lei to 2,000 lei. This amendment, of course, with this amendment, the limited liability company has lost one of its main features. However, the legislation clearly stipulates that the company shares of a limited liability company cannot be issued as securities. Now, talking about this low capital requirement, it has both positive and negative aspects. Let's start with the positive ones. The low level of compulsory capital allows the easy creation of a limited liability company, which can be a significant competitive advantage to Romania compared to other countries. And of course, this easy creation of limited liability companies also explains why the number of general and limited partnerships is low in practice, as you could see in the statistical data shown. However, to law, the capital requirement also has its drawbacks, because the size of a company's capital is the indicator of for those who wish to enter into contract with the company. And the level of the company's capital indicates the company's seriousness, the company's weight. Therefore, the setting of a minimum capital level for the company is a really sensitive economic and also legal problem, because, as you can said, too low the minimum level of capital can encourage irresponsible entrepreneurship, and also the creation of fictitious companies or abuses at the expense of other market actors. But too high the minimum capital requirement will probably discourage small businesses. In Romania, the elimination of the minimum level of the capital for limited liability companies was a conscious economic policy choice, which of course bears its serious risks as well. Now, the number of associates shareholders. First, in case of the joint stock company, the number of shareholders shall not be less than 2. If the company has fewer than 2 shareholders for a period of more than 9 months, then any interested person may apply to the judicial authority to dissolve the company. Now, companies with the sole or majority state capital, they may have any number of associate members. Thus, there exist single-member joint stock companies owned by the state or local government. Talking about the limited liability company, this can be set up by a single person. However, here we have a maximum limit. The number of members here may not exceed 50. Originally, the same natural or legal person could create a single one-person company under the Romanian regulation, and one-person limited liability company couldn't create one-person limited liability company. And the aim of this legislation was the creditor protection to prevent assets from sole proprietorships being divided between separate legal entities to the detriment of the creditors. However, Act number 102 of 2020 removed this restriction. Talking about the general partnership and simple limited partnership under Romanian law, there is no provision regarding these aspects. However, due to the contractual nature of also of these companies, it can be said that these kind of companies also in the establishment of these kind of companies, a minimum of 2 persons are required to form a company. In conclusion, I have attempted to address some broad issues within the Romanian company law, emphasizing the significant differences among various legal approaches. However, this variability is to be expected. In company law, it is appropriate that this harmonization is only partial, which leaves enough space for legal innovation. Thank you for your attention.